the start, you're on the right path. It's always easier to be on the right path from the get-go instead of having to correct something that may have gone wrong and not properly. If you lose some information, for example, you can't get it back. So, Tony, please reach out to someone quickly to make sure that claim is properly reserved and that your individual is taken care of. So that was our first email, and now that we get here, let me introduce one of our longtime guests, Doug Smith.
Well, thank you, Ted. It's nice being here again, yes. And we're lucky Chris Young's not here tonight because all he would talk about was that LSU baseball. That's all he would talk about.
Well, I would get to throw in a couple jabs. My Gators actually qualified first for the World Series, but LSU is in as well.
So SEC, they know how to play baseball.
It's going to be good. But Doug, I know you've been on the show many times, but if you would just briefly for the audience, tell them where you work and the kind of practice that you have.
All right. Well, with the passage of time, I'm one of the senior partners at Burke Blue. We're primarily a civil practice law firm, and I've been a member of the Florida Bar over 3 decades. But I don't feel so old, but I guess I am. But I've done a variety of things. Back years ago, before you became a personal injury lawyer, we had cases together.
We had many cases together, yes, we did.
So anyway, but I do enjoy the practice of law.
Very good.
Meet a lot of nice people, and it's a people industry.
Yes, it is, Doug. And speaking of people, I think we have our first call on the line. Tammy, if you would go ahead with your question. Tammy?
Yes. Can you hear?
Go ahead, Tammy.
Hello? Yes. I am wondering, in the event of my mother's death, how would I get added onto her property if I'm not on her listed on her deed?
Okay, that's a very good question, Tammy. It falls into the estate arena, and Doug, I know that's something you practice in from time to time, and I did in the past as well. And just if you would just kind of briefly go over the scenarios of the options that Tammy has, and really it's her mother's options, but how they could potentially have that transfer happen.
Yeah, what I would do, Ted, of course, if Tammy called our firm, I would talk to our attorneys who specialize in probate and estate planning, and if the mother wanted Tammy to inherit, when she passes on, she'd need to obviously plan ahead, and she could in various ways add Tammy to the deed to the property, make it a survivorship deed. But there's reasons why to do that and not, and so it's estate planning attorneys who the mother should speak to in terms of planning it. And then afterward, I mean, if Tammy were either an heir at law or mentioned in the will, probate might be needed to get it done. So it's really not, it's not my main area of practice.
But Tammy, it's always important to have that conversation with her mom so that she knows, however she wishes the property to ultimately go, that's taken care of in advance. As Mr. Smith mentioned, you can do things such as life estate deeds and other things that can still, depending on how it's drafted, give your mother legal rights to the property now, but have it where it's going to pass to you as a matter of law, or whomever she wants it to pass to when she passes away. Otherwise, if she doesn't prepare for it in a will, it's going to have to pass under intestacy laws, which is going to go to any other siblings or however your family dynamics are set up. So it's important. It's not something we like to talk about, and we all have, we are mortal, and so it will come to an end at some point. So it's important that you plan so that things are done as you would like them to do and not as the state dictates or mandates.
Right. Absolutely.
So very good question, Tammy. Anybody else, make sure and give us a call, 850-392-1544, or you can email us at lawcall@wmbb.com. Doug, I know we've talked on the show a lot about some of the changes we've had with tort reform here in the state on the personal injury context. I know you do a lot of commercial litigation and things like that. Are there any changes that you're seeing coming along and down the pipelines that are affecting the Florida residents that they need to be aware of?
Well, and I know just from seeing in the news that there's been some rather significant changes in your area, the personal injury stuff. I'm not sure what all those are, but I know that harder to bring claims somehow, right?
And Doug, we actually had another caller on the line, I believe, from Walton County. Nicole, if you would go ahead. Actually, Holmes County. Sorry, Nicole.
Hi, yes. Can you hear me?
I can, Nicole. Thank you.
Hi, yes. Okay, I'm just wondering, are you allowed to drink non-alcoholic beer while you're driving? And if you got pulled over with a bottle of non-alcoholic beer driving, can that get you in trouble?
Okay, Nicole's asking a question about drinking non-alcoholic beverages and whether that would have any sort of culpability or liability. I know neither Doug or I practice criminal law, but the laws about being in violation of intoxicating beverages are as if you're actually raising your blood alcohol level, and as long as that beverage is not raising your blood alcohol level and doesn't have an alcohol content, I don't see a reason why that would be anything that would be violative of the law, unless there's something I'm missing, Doug.
Yeah, I can't see how it would matter. Just, I mean, everyone has to pay attention when they're driving, and even when I'm drinking my soda heading down the road, I gotta
pay attention.
Not let the soda mess up my ability to drive the car.
Well, and that's a good point, Doug. I mean, one of the worst dangers we have in the road, and we all see it when we're driving down, is the texting and driving.
Oh, boy.
And in fact, there's studies out there with the texting being, like being in excess of 0.20 BAC, at the same level of distraction, because you can text and put your head down, and the next thing you know, you've gone a couple of hundred football fields. Not a couple hundred yards, not a couple of football fields. But it's important to make sure you're not distracted. But the intoxicating aspect is a whole different issue. And as long as that beverage is not having an intoxicating effect and not raising your blood alcohol level, and it's not just limited to intoxicating. If you're taking some sort of drugs or pills or whatever that is impairing your faculties and limiting your ability to properly navigate those roadways, that's another factor.
Even a properly prescribed prescription, if it affects your ability to drive, you shouldn't do that.
Right. You always got to read the back of those bottles, because it'll give you those warnings, and many times your health professional should be giving you the advice and recommendations on that as well. So be careful with all of those, and make sure that you're following those rules and procedures. Doug, one question I get, I'm just thinking on the Ask Us Anything type arena, is, somebody promised to do something for me in exchange for some sort of consideration, but we didn't write it down. Is that somehow an enforceable contract or not?
Well, you're getting into what we all studied back in law school and the bar and everything, statute of frauds. Does it have to be in writing? And certain things do, like, for example, real estate contracts have to be in writing. There are other things too. I always go back and look at the statute, something about products over $500 and things that can be performed within a year and all that stuff. But
let me get this. I think we got a question here on the
caller?
lines right now, Doug. Let me get to this real quickly. This is Ben from
Okay.
Bay County. Ben, go ahead.
Yes, I have a question. We have a will that has been prepared. It's been prepared for several years now, and I've heard that most wills have to be probated, even if you have a power of attorney or someone designated to handle the will. Is that correct?
Okay, very good question, Ben. And Ben is asking if there's some way, just because you have a will, does that mean you get out of probate?
yeah, and the answer is sure. I mean, a lot of times husband and wives have what they call mirror wills, and when the first spouse passes on, if things have been set up properly, the other spouse inherits things.
Right.
And, accounts are in the two names, and it's a transfer on death. And so just because you have a will doesn't mean they'll necessarily be probate. It also doesn't mean that it's going to be some expensive drag-out process. There's summary administration. If, say the example I gave with the mirror wills, when the second spouse passes on, if they have not made pre-arrangements, like it goes back to the first question from Tammy, right? About, who's going to get the property. But a lot of these things can be done summary administration, and you know, I find, you probably do too, Ted, that some of these things, you know, they try, some folks, they have, you know, big fancy trusts, and not everyone needs that. I mean, you know, the average person probably doesn't need it. But
Ben, what's important to know, though, is that power of attorney has no effect as soon as someone passes away. That's null and void at that point in time, because you can only act as a power of attorney if the principal is available to act. So that's not going to be any good. And if there's anything that actually needs to transfer, you are going to have to probate that will, because you have to actually get the power to the personal representative to act, which can only be done by the court. Hopefully you've done the things that Doug has mentioned with bank accounts and things so that they pass automatically without having to use the will. But to the extent you need that will, you're going to have to deposit it with the court and either do the summary or whatever administration will be necessary. Yeah. But we'll be right. We're going to have to take us a break real quickly now. We'll be right back, and the phone lines are open, 850-392-1544. LawCall. Just remember those phone lines are open, 850-392-1544. And during the break, I think we had a phone call from Ronnie.
Happened to me. And I switched to T-Mobile.
Ronnie, can you make sure to turn your TV off in the background? Thank you, Ronnie. Ronnie, if you would, talk into the phone, please.
Yeah, how you doing?
I'm all right, Ronnie.
Okay.
Go ahead.
All right. What it is, my mother filed for my father's death benefits. He died in 2017. She's recently filed in November. And what happened was, it was found out that he was suspended 4 checks because the payee, my payee, I didn't really fill that form out. So what happened was, there's $4,200 left. And so they did the other paperwork, but the $4,200, they can't find all of a sudden. So I've been calling. Last month, they told me on the 8th of May that wait a month, and I did. I called June 8th, and now the money's just missing, so they don't know what's going on. So the lady said they're going to do a manager request to find out where the money's at. But they're getting some kind of impatient and nasty towards me when I call, and I'm wondering what can I do as far as find out where the money is at, because $4,200, they can't find it now.
Right. I'm sorry you're dealing with that, Ronnie. That's a very difficult situation to deal with, on top of losing your parents. And Doug, what do you think about this?
Well, I think since Ronnie's up there in Abbeville, Alabama, you know, he probably should see if there are some local attorneys who practice Social Security law up there, and go to one, because they know how to navigate the system. That it's an area you and I don't really.
And Ronnie, this
even
is
in Florida
this is
here.
what happens. And typically, people see this in the insurance context where we're dealing with. They get the run around. They keep getting told to go here, to go there. In a situation like this, Ronnie, I would absolutely get in touch with somebody that handles and specializes in Social Security benefits and make sure that you get that done so that you can go ahead and get that finality of this part of it and can move on. But I am very sorry that you're dealing with that. So Ronnie, make sure and do that first thing Monday morning, and if you need to, call our offices. We'll make sure and help you get connected with someone. I think we have another phone call on the lines right now. Alan, go ahead, from Jackson County.
Yes, sir. I was calling, sir. I've been having a couple of issues. I had a grandmother pass some years back, and I was young when she passed, and they claimed that she had a will and that everything was never brought through the probate. And I'm just trying to figure out what would I need to go about doing to find out the proper information on it.
That's very good, Alan. Alan, did she pass away in Jackson County?
Yes, sir.
Okay, very good, Alan. The first step that you need to do is you need to reach out to the clerks of court and see if there was actually an estate opened in Jackson County. And you can get a hold and contact them, and they can give you a copy of what's called the docket sheet so that you can see everything that happened in that case, if it did in fact happen. And you can go through, and there should be things such as an accounting and a distribution that can show you where all the assets went and who all of the beneficiaries were. Now, if for some reason there was a will and it was not probated, you need to try to locate that original will, because original wills, Doug, are one of the few documents that we're still that have some serious legal significance.
There's a presumption, if you don't have the original will, that it was intentionally destroyed. That's the presumption.
Right.
It can be overcome, but
No, so it's important to make sure if you find out that it was not done, that you actually try to locate that, and then it can even be probated now at this late date, and it's not unusual. A lot of times, if families are holding on to properties, I've seen it a lot in our areas where that you can even have a couple of generations removed and property still in the name of a grandparent, for example. And then that can create a lot of mess for the folks when they're trying to ultimately sell that property. No stir as long as there's actually family members living in there, but once you go to try to transfer that interest, it can become an issue and can potentially, you're talking about a grandmother in this potential scenario, that could potentially require 2 levels of probate in order to get, and maybe even more, to get that property, if it's real estate, cleared or whatever the assets are. So make sure, Ronnie, first step, go into the clerk's office, see what was done or what wasn't done, and then next step, if it wasn't done, make sure and locate any documentation that you can about an original will. If not, it's going to pass via intestate laws, which, because it was 2 generations removed, may require a couple levels. But Ronnie, good luck with that. Now we have another call on the line. This is JD in Lake County, watching on YouTube Live. Thank you, JD. Give us your information.
Well, unfortunately, I'd like to probably the first part is my mother was undergoing cancer surgery. When she went back to the apartment she shared with my father, she found that they had thrown my father, where they usually have that, they throw ashes within the organ donation box with his Bible and his veteran's flag, was tossed in the dumpster, and then she sees that all of her belongings had been tossed in the dumpster. We were just going in trying to get her mail and get some of her medicines. She sees all of that. This was back in January of this year, and she just died March 5th of this year. Everything I'm seeing, it's that kind of, it's a wrongful death. I think that I need to pursue a little bit on that. But I know with the power of attorneys that I was caregiver for everybody in the family, that the power of attorney dies at death. I'm trying to see how to proceed to, basically, that was just heinous what they did at that apartment that my mother and father shared, how to go after them in some form or matter, because that was inexcusable what they did there. And then also her self-storage unit that she had, I went in with the small estate affidavit and finally got the cause of death, death certificate this week. They refused me access because my mother had left everything to her dog. As she knew, with the half a dozen other relatives, I would still be there as caregiver for her dog because that was her favorite child. So how do I proceed in going after the apartment that malicious, heinous act against my father who was tossed in the trash, and then how that affected my mother, as well as how do I gain access to the self-storage unit to see what did she even have in there and how to proceed on that?
Well, JD, as you correctly stated, the power of attorney over your mother is no longer valid at this point since she's passed away, because a power of attorney can only be utilized as long as the principal can actually act. But in order to actually pursue her estate in any capacity, you're going to have to open a probate. And if you are the sole son, you are likely the proper person to be the executor or personal representative of that estate. As that personal representative or executor, you're allowed to pursue any claims that would have been viable for your mother. For example, the issue with the tossing of the belongings. That would not per se be a wrongful death case. That's a case it's called a survival case. So if that person could have brought it, you can bring it as the personal representative of the estate. Now, if there is some sort of claim arising out of or relating to her death, the personal representative is the lone person that can bring that claim under what's called the wrongful death statute. And under the wrongful death statute, there's certain designated persons that are called wrongful death beneficiaries, one of which would be you. Your father, if he's still alive, he would be one of the beneficiaries as well, and any other siblings. But just no matter how she left the estate, the wrongful death statute governs how the recovery goes for any wrongful death that was caused, any of the treatment at the end of care that may have led to that. But likewise, or on a second note, is the survival action that is just any kind of cause of action that the individual would have had prior to death, whether it be breach of contract, if they need to do an eviction of a piece of real estate, a foreclosure, you name it, anything that individual would need to pursue, you as the personal representative are allowed to pursue that. Now those proceeds would flow just like the will has them flow. So if the ultimate beneficiary is some sort of trust or other mechanism that's been set up for this animal, then that would be the ultimate beneficiary of those survival cases. Now, the wrongful death would be only the family members would be the ones that would be the ultimate beneficiaries of those. So good luck with that. We're going to take our last break now, but please give us a call when we come back. Welcome back to Law Call. Once again, Ted Howell and the infamous Doug Smith here with me.
It's been fun, Ted. The half hour has flown by.
It has.
I did want to say one thing real quick.
Yeah, go ahead.
Remember Ben earlier? He was the one who was asking about will and probate and everything. I just wanted to say that it's not our area, but you know, every adult in Florida should have, you know, a simple will, a power of attorney, healthcare surrogate. And some people often overlook is once your child hits 18, they're a legal adult. And if they don't have a healthcare surrogate and all that, you know, God forbid, but your adult child is in the hospital and like you go in, oh, I'm here to help, and they're like, who are you? And so every adult in Florida, we don't do this area of work, but we have lawyers at our firm, and you have people you refer to. They ought to have a will, power of attorney, and a healthcare surrogate. They just ought to.
The most important thing is just to do the things that make sure you have it where you want it to do. So thank you guys, and it's been a good show, and we'll see you next time.